Hello and welcome back to Bite-Sized Law. This is the second of 4 videos on interests which override under the Land Registration Act 2002, Schedule 3, Paragraph 2. In this video I'm looking at the situation where a third party has a proprietary interest and was in actual occupation of land at the time of a disposition, but does not have an interest which overrides because their situation falls within one of the 2 exceptions I'm about to discuss. So here is the text of the statute, and just to remind you that I've removed paragraph A because it doesn't apply to third parties who are claiming their interest overrides because they're occupying the property. So if we break it down into bite-sized pieces, you can see that there are 2 exceptions and each has its own particular requirements. If you don't like the words except for, try substituting the word unless. So a third party with an interest who is in occupation will have an interest that overrides, which is the general rule, unless any of the exceptions that we're about to look at apply. So the first exception is non-disclosure when asked in paragraph B. And you can see that there are 2 requirements. So for this exception to apply, the purchaser must ask the third party if they have an interest, and the third party failed to disclose their interest and they should have done so. In other words, it would have been reasonable for the third party to respond to the purchaser's inquiry. In other words, what the purchaser is relying on here is that they gave the third party the opportunity to tell them about their interest and they didn't when they could have done so. And just note that the purchaser must ask the third party. It's not sufficient to rely on an answer from the seller. The other thing to appreciate is that the purchaser can only rely on this exception if they ask the question. So if they don't ask, then this exception isn't engaged. So let's see how this particular exception applies to Boris and Teresa. Here are the facts again, just to remind you, and you might want to hit the pause button to read them to refresh your memory. So here's the text of the statute again, and the best way to deal with it is to deal with each requirement in turn. So let's look at the first requirement. So the issue is whether this exception applies, and the rule that we're going to apply is the first requirement in paragraph B. So now let's apply that to the facts. Well, Boris didn't ask. So we can immediately conclude that the requirements of paragraph 2B haven't been satisfied, which is very bad news for Boris because it means that he can't rely on this particular exception. And I just want to point out that it's important to appreciate at this stage that there's now no point in looking at the second requirement in paragraph B. So your discussion of this particular exception ends here. So any discussion of whether it would have been reasonable for Teresa to respond if she had been asked is irrelevant. And if you include this, you won't get any credit for it, and in fact it will reduce the overall quality of your answer. So now let's move on to look at the second exception, and in my opinion this is the one that students struggle with the most, and unfortunately it is also very popular with examiners. So here is the text, and again notice that it's in 2 parts. They're separated by the word and, which means that they are not alternatives. They must both be satisfied for this exception to apply. What I've done on this slide is to add in the relevant details from our example to help you understand what to focus on in each part. So first of all, it refers to an interest. Well, this is simply the interest that the third party has. So in our example, it's Teresa's beneficial interest under a trust. Jeremy was holding Yellow Door on trust for himself and Teresa. And in the first part, you focus on Teresa's occupation and whether it would have been obvious or not on a reasonably careful inspection of the land. In the second part, you focus on the purchaser's knowledge. So did Boris have actual knowledge of Teresa's interest at the time of the disposition? And this is where students can sometimes get into a mess, because if you remember, the exception in paragraph 2b also deals with whether the purchaser asked about the third party's interest. But remember that they are two completely different exceptions with different tests, so don't try and deal with them at the same time. And there are a couple of things I want to stress here. In the first paragraph, you're focusing on evidence of Teresa's occupation, and in the second paragraph, you're focusing on whether the purchaser had knowledge of her interest. So it's not knowledge of her occupation, it's knowledge of her interest. So here's a summary of what we've seen so far. The third party's occupation must not be obvious on a reasonably careful inspection of the land, and the purchaser must have no actual knowledge of the third party's interest, and if both of those requirements are satisfied, then this particular exception will apply. So now let's look at those two requirements in a little bit more detail. Here's the text of the first requirement, and remember that it's referring to the third party's occupation, which must not be obvious on a reasonably careful inspection of the land. And there are 2 points I want you to appreciate here. The first is that the third party's occupation must not be obvious, and always use that word obvious from the statute. And you need to understand that this is a hypothetical test, so it's irrelevant whether the purchaser actually inspected or not. What you're looking for is, would the occupation have been obvious or not if an inspection had been made? And then the second thing to appreciate is that the standard of inspection is a reasonably careful inspection, and this is an objective test. So it's not about what a purchaser did or didn't do, it's what a reasonable purchaser would have done. So let's see how we might apply this exception to the facts of Boris and Teresa. And what I've done is to highlight the facts that we're going to use in green. So I've noted that the seller is a sole male legal owner, and that there were female belongings left out in the bathroom and in a separate bedroom, but Boris, the purchaser, failed to notice them. So here's how I would deal with this using the IRAC method. So the issue that we're considering is whether the exception in paragraph 2c applies, and the rule we're applying is the first requirement in the statute. And note that I have quoted directly from the statute there. It's perfectly acceptable to use short and relevant quotations from statutes, just pop them in quotation marks and that'll be fine. And when we come to apply that rule, well, I would explain that Jeremy was a sole male legal owner, but there was evidence that somebody else was living there with him because there were female items left out for anybody to see in the bathroom and in a separate bedroom. And although Boris failed to notice them, remember that we're applying an objective standard. So if a purchaser had carried out a reasonably careful inspection, it would have been obvious that somebody else was living there besides Jeremy. So our conclusion will be that Teresa's occupation was obvious on a reasonably careful inspection of the land. So the conclusion that we can reach is that the requirements of the exception of paragraph 2c haven't been satisfied. So this exception doesn't apply either. And again, note that any discussion now of the second requirement in paragraph 2c is irrelevant. So remember that a good answer is not only about what you put in it, it's also about what you choose to leave out. So the final conclusion that we arrive at is that neither of the exceptions apply, which is very bad news for Boris because Teresa's interest will override the sale to him. Now what I've done here is I've changed the facts slightly because I want to show you how your answer would be different on the changed facts. And the changes are highlighted in red. What you can see is that Boris doesn't visit Yellow Door this time, and that Jeremy had packed up all of Teresa's belongings and put them in the attic. So again, using the IRAC method, the issue is exactly the same, the rule is exactly the same, but this time the application of the rule to the facts is going to change. So remember, first of all, it's irrelevant that Boris didn't inspect Yellow Door because it's a hypothetical test. However, a reasonably careful inspection of the land would not require a purchaser to look in cupboards or open drawers, and certainly not include looking in boxes stored away in the attic. So this time, Teresa's occupation wasn't obvious on a reasonably careful inspection of the land, so we can conclude that the requirements have been satisfied. And before we move on, I just want to clarify something here. We saw in the first video that the third party must be in actual occupation of the property at the time of the disposition. And although we've changed the facts, this is still the case because there's still evidence that Teresa intended to return to Yellow Door. She still left her belongings there. It's simply that now they are stored away in the attic, which doesn't affect our original conclusion that there's evidence that she intended to return to Yellow Door and therefore is in actual occupation. So what we've just seen is that the first requirement has been satisfied on our changed facts. So now we have to deal with the second requirement, and this is something that students can forget to do. But if you follow the wording of the statute, then you shouldn't make this mistake. So here's the text of the statute, and you can see that the rule states that the purchaser, Boris, must have no actual knowledge of Teresa's interest at the time of the disposition. Now the statute states that the purchaser should have no actual knowledge of the interest, but the courts have interpreted this to include no knowledge of the facts giving rise to the interest. So let's see how we're going to deal with that in relation to Boris and Teresa. Well, the issue is whether the second requirement in paragraph 2c has been satisfied. And I've stated the rule by quoting the relevant parts from the statute and also added in that the courts have interpreted interest to include facts giving rise to the interest. So when we apply that, well, Boris was aware of the facts giving rise to Teresa's interest because she told him that she had contributed towards the purchase price. But of course, it's important to note that he didn't have knowledge of those facts until after the disposition. So we can conclude that the requirements have been satisfied. So we've just seen that one of the exceptions does apply, so we can conclude that Teresa's interest is not going to override. And remember that you've been asked to advise Boris, so you must do this. Incidentally, I have seen students advise the wrong party here, so just be careful. Don't advise Teresa. Remember that you're advising Boris. So our final advice would be that we would advise Boris that Teresa's interest does not override the sale to him under the Land Registration Act 2002, Schedule 3, Paragraph 2. And because it's so easy to forget to do that last part, a quick way to check that you've completed your answer is to go back and remind yourself what you said the general issue was, which I've highlighted in pink here, and make sure that you answer it. So let's just quickly summarise how the exceptions work. As we've just seen, if either of the exceptions apply, then the third party won't have an interest which overrides. On the other hand, if neither of them apply, then the third party will have an interest which overrides under Schedule 3, Paragraph 2. And here's a summary of what your answer would look like if neither of the exceptions applied. So assume that Teresa's things were obvious on a reasonably careful inspection of the land. So here's a summary of what we've covered in videos 1 and 2. Thank you very much for watching. I hope that you found the video useful, and if you have, please subscribe to my channel or like or share, because it really does make a difference. In the next video, I'll be looking at the common mistakes students make and give you some tips on how you can avoid them. And I'll also share some tips with you about how to make life easier for yourself when you're answering a question in an exam. Thank you again for watching.